Good morning and welcome to today's Cobb County Board of Commissioners zoning hearing this June 21st, 2026. I'm pleased today that we have Father Eric Hill of Transfiguration Catholic Church here today. He will be providing our invocation, which will be followed by the pledge. For those of you who are willing and able, please stand for both our invocation and our pledge.
Good and gracious God, we come before you today with grateful hearts, thanking you for the privilege of gathering freely to serve the people of Cobb County. We thank you for your presence in the room this day. Grant these commissioners exceptional wisdom, discernment, and patience as they deliberate on the matters before them. Help them to listen with open minds, to speak with respect and clarity, and to make decisions that promote justice, safety, and prosperity for every corner of our county. Give them the strength to carry the weight of leadership and remind us all of our shared responsibility to look out for one another. May the work done here today honor you and bring you lasting good to the residents of Cobb County. And the church says, amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Father Hill. Appreciate that invocation today. Our meeting is now called to order, and I will turn things over to John Peterson, our zoning manager, who will walk us through today's agenda.
And thank you, Madam Chair and Board. Today's hearing will be conducted with the following process and procedure. When the case is called, we would ask that the applicant please stand and raise their hand to show that they are in attendance. After that, we're going to call to see if there's anyone here opposed to that specific case. We would also ask that the opposition please stand and raise their hand so they can be counted for the official record. After recognizing both parties will be asked to come forward, be sworn in, so they can present testimony to the Board of Commissioners. The applicant will testify first, and then the opposition, if any, will testify second. It's important to note that each side gets 10 minutes to state their case and concerns. There's not a rebuttal process, and there's not a process to reserve your time. So please convey all your information to the board within your 10-minute time frame. Additionally, if there's more than one person here wishes to speak on a case, you may want to coordinate with each other about what you're going to talk about, because each side only gets 10 minutes, and you don't want to cover the same information over and over. After that, the board will start to discuss the case at hand. From the discussion, they may ask one or more speakers to come back to the front for additional comments or questions. Then the board will make a decision to either approve, deny, hold, or continue the matter at hand. There are two cases on today's agenda which have been withdrawn without prejudice, and these cases will not be heard today. First case is LEP 15 of 2026, Robert Manton. This case has been withdrawn without prejudice, so Z15 of 2026 will not be heard today. Secondly, other business item number 35 of 2026, O'Connor Development Group, LLC. This case has been withdrawn without prejudice, so OB 35 will not be heard today. There are a number of cases on today's printed agenda which have been either held or continued, and these cases will not be heard either. First case is rezoning case Z1 of 2026, Francisco J. Garcia Sanchez. This case was continued by the Planning Commission until the September 1st, 2026 Planning Commission zoning hearing, so Z1 of 2026 will not be heard today. Rezoning case Z13 of 2026, Presswick Companies. This case was continued by staff until the August 4th, 2026 Planning Commission zoning hearing, so Z13 of 2026 will not be heard today. Rezoning case Z17 of 2026, Hario Murillo. This case was held by the Planning Commission until the August 4th, 2026 Planning Commission zoning hearing, so Z17 of 2026 will not be heard today. Rezoning case Z21 of 2026, Branch Acquisition Company, LLC. This case was held by the Planning Commission until the August 4th, 2026 Planning Commission zoning hearing, so Z21 of 2026 will not be heard today. Rezoning case Z22 of 2026, The Haven at Eastside, Inc. This case was continued by the Planning Commission until the August 4th, 2026 Planning Commission zoning hearing, so rezoning case Z22 of 2026 will not be heard today. Rezoning case Z25 of 2026, Elite Engineering. This case was held by the Planning Commission until the August 4th, 2026 Planning Commission zoning hearing. So Z25 of 2026 will not be heard today. Rezoning case Z27 of 2026, KRG Development LLC. This case was continued by the staff until the August 4th, 2026 Planning Commission zoning hearing. So Z27 of 2026 will not be heard today. Rezoning case Z28 of 2026, Connor Thorpe. This case was continued by the Planning Commission until the August 4th, 2026 Planning Commission zoning hearing. So Z28 of 2026 will not be heard today. LEP 6 of 2026, Tasha Tolbert and Alicia Steele. This case was continued by the staff until the September 1st, 2026 Planning Commission zoning hearing. So LEP 6 of 2026 will not be heard today. LEP 7 of 2026, Jessica Weaver. This case was held by the Board of Commissioners until the August 18th, 2026 Board of Commissioners zoning hearing. So LEP 7 of 2026 will not be heard today. LEP 14 of 2026, Stephen Van Ginkel. This case was held by the Planning Commission until the September 1st, 2026 Planning Commission zoning hearing. So LEP 14 of 2026 will not be heard today. SLEP 6 of 2026, Wollaston Enterprises LLC. This case was continued by the staff until the August 4th, 2026 Planning Commission zoning hearing. So SLEP 6 of 2026 will not be heard today. And finally, other business item number 29 of 2026, Sydney and Amber Silva. This case was continued by staff until the August 18th, 2026 Board of Commissioners zoning hearing. So other business item number 29 of 2026 will not be heard today. Madam Chair and Board, I did get one request this morning to continue one other case that's on the printed agenda. The applicant would like to continue SLEP 3 of 2026, Joe Dirt Development, until your August 18th hearing, Madam Chair and Board. The applicant is in discussions with the neighbors and would like to continue this case one more time.
Okay, Commissioner Allen,
So moved.
Second.
is there any discussion? Call the question. The motion carries 5-0.
Thank you. And before we begin the consent agenda, I do have just two more announcements. If you have a cell phone, please turn the volume off on your cell phones. When the phones ring, it does interfere with the broadcast and presentations. And I want to remind applicants, opposition, or any interested party that information is due to this board the Wednesday prior to this hearing. Any information submitted after the Wednesday due date may or may not be considered by the board at their discretion. And with that, Madam Chair and Board, I'm ready to start the consent agenda.
Yes, please.
Cobb County Board of Commissioners zoning hearing consent agenda for July 21st, 2026. First case on consent is LEP 12, Juan R. Vasquez. Requests a temporary land use permit to allow more vehicles parked outside than the code allows in land lot 810 of the 19th District. The property is located on the north side of Pearson Road, west of Hiram Lithia Springs Road. The Planning Commission recommends approval of LUP 12 for 18 months, subject to the following condition. Number one, construction of a garage during said time frame to house additional vehicles. Is the applicant present? Yes. Let the record show the applicant is here. Is there anyone here opposed to LUP 12? Okay, let the record show there's no one opposed. LEP 13, Rebecca Yan requests a temporary land use permit to allow the growing and selling of cut flowers in land lot 157 of the 20th District. The property is located on the south side of County Line Road. Staff recommends approval of LUP 13 for 24 months, subject to the following conditions. Number one, no commercial deliveries after sunset or before sunrise. Number two, sign elevations received by the zoning division on July 14, 2026, with any changes to be approved by the district commissioner. Number three, clients to park in the driveway. Number four, maximum of 35 clients per week. Number five, fire department comments and recommendations. Number six, stormwater management division comments and recommendations. And number seven, Department of Transportation comments and recommendations. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to LEP 13? Okay, let the record show there's no one opposed. And moving into other business cases on consent. First one is other business item number 31 of 2026, which is to consider a lot size reduction from a required 80,000 square feet to 11,614 square feet for Tract 1 and to 8,263 square feet for Tract 2. Reduce required public road frontages from 75 feet to 0 feet for both tracks and other variances for William Mungie. The property is located on the south side of Old Dallas Road in Land Lot 30 of the 19th District. Staff recommends approval, subject to the following conditions. Number one, lot size reductions and variances as shown on the site plan received May 15th, 2026. Number two, fire department comments and recommendations contained in the other business packet. Number three, Cobb DOT comments contained in the other business packet. And number four, maximum house footprint on tract 1 be 1,000 square feet. Is the applicant present? Okay, let the record show the applicant is here. Is there anyone here opposed to other business on number 31? Okay, we have one person opposed, so we'll pull that one off consent, Madam Chair and Board, and we'll put it in its regular order.
Okay, just want to share for the applicant, you're encouraged to speak to who's in opposition to see if you're able to address their matter, and we may possibly be able to get that back on consent.
Okay, would the person who opposed please stand up, okay? Just talk to them out in the lobby, sir, and see if we can get things worked out. If not, we'll just hear it in its normal order.
Yes, thank you.
All right, next case is other business item number 33 of 2026, which is to consider a lot size reduction from required 20,000 square feet to 14,664 square feet for tract 1 and the 14,665 square feet for tract 2 and other variances for Joselio Cruz. The property is located on the east side of Woods Lane, south of Harris Court, in land lot 91 of the 17th District. Staff recommends approval, subject to the following conditions. Number one, lot size reductions and variances as shown on the site plan received by the zoning division on June 3rd, 2026. Number two, water and sewer comments. Number three, site plan review comments. And number four, stormwater management comments. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to other business on number 33? So we got one. So we'll pull that one off also, Madam Chair and Board. And
Yes.
If the applicant can meet with the opposition and see if they can work out something, we might be able to put that back on consent.
Thank you.
All right, next case is other business item number 36 of 2026, which is to consider amending the stipulations and site plan for Curley Family Homes LLC regarding rezoning application Z89 of 2021. The property is located on the west side of Austell Powder Springs Road, south of Old Austell Road, in land lot 979 of the 19th District. Staff recommends approval, subject to the following conditions. Number one, site plan received by the zoning division on June 15, 2026. Number two, water and sewer comments. Number three, site plan review comments. Number four, fire department comments. Number five, Cobb DOT comments. And number six, stormwater management comments. Is the applicant present? The applicant is here. Is there anyone here opposed to other business item number 36? Okay, let the record show there's no one opposed. Next case on consent is other business item number 37 of 2026, which is to consider amending the stipulations and site plan for Sharon Foster regarding rezoning application 279 of 1983. The property is located at the southwest corner of Canton Road and Coventry Drive in land lot 350 of the 16th District. Staff recommends approval, subject to the following conditions. Number one, site plan received by the zoning division on June 16, 2026. Number two, fire department comments. Number three, Cobb DOT comments. And number four, stormwater management comments. Is the applicant present? Okay, let the record show the applicant is here. Is there anyone here opposed to other business item number 37? Okay, let the record show there's no one opposed. Next.
Commissioner Burrow has a comment.
I just wanted to compliment you on how nice the yard landscaping and the aesthetics look from your building. It's a big improvement from what it used to be, so thank you.
Okay, next case is other business item number 39 of 2026, which is to consider amending the stipulations and site plan for Hickory Grove Self-Storage LLC regarding rezoning application Z79 of 2021 and SLUP 10 of 2021. The property is located on the south side of Hickory Grove Road, west of Way Green Road, in land lot 55 of the 20th District. Staff recommends approval, subject to the following conditions. Number one, site plan received by the zoning division on June 16, 2026. with the district commissioner approving minor modifications. Number 2, water and sewer comments. Number 3, fire comments. And number 4, stormwater management comments. The applicant is here. Is there anyone here opposed to other business item number 39? Okay, let the record show there's no one opposed. Next case is other business item number 40 of 2026, which is to consider a stipulation and site plan amendment for O'Dwyer Properties regarding rezoning application Z34 of 2016 for property located on the northeast side of Hickory Grove Road, west of Hickory Grove Place, in land lots 54 and 55 of the 20th District. Staff recommends approval, subject to the following conditions. Number 1, proposed site plan contained in the other business packet. Number 2, proposed new house to be a maximum of 2,150 square feet of heated and cooled living space. Number 3, water and sewer comments. Number 4, fire department comments. Number 5, site plan review comments. And number 6, stormwater management comments. The applicant is here. Is there anyone here opposed to other business item number 40? Okay, let the record show there's no one opposed. Next case is other business item number 41 of 2026, which is to consider a stipulation amendment for Sam Baskin Jr. regarding rezoning application Z32 of 2011 for property located on the west side of Austell Road, south of Patmel Road, in land lot 85 of the 17th District. Staff recommends approval, subject to the following conditions. Number 1, property to be used for offices, a print shop, or community retail uses. Number 2, no outdoor storage or outdoor display of merchandise. Number 3, no automotive-related uses. Number 4, stormwater management comments. Number 5, fire department comments. And number 6, all previous stipulations not in conflict to remain in effect. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to other business item number 41? Okay, let the record show there's no one opposed. Next case is other business item number 42 of 2026, which is to consider a stipulation and site plan amendment and other variances for Absolute Beauty Salon and Suite LLC for property located at the southeastern intersection of Scott Drive and Scott Circle in land lot 1242 of the 16th District. Staff recommends approval, subject to the following conditions. Number 1, site plan received by the Zoning Division on June 16, 2026. Number 2, Cobb DOT comments. Number 3, stormwater management comments. Number 4, site plan review comments. And number 5, fire department comments. Is the applicant present? Okay, let the record show the applicant is present. Is there anyone here opposed to other business item number 42? Okay, let the record show there's no one opposed. And last item on consent is other business item number 43 of 2026, which is to consider a stipulation and site plan amendment for Spring Lake Village LLC regarding rezoning application Z29-2023, located in land lot 893 and 894 of the 19th District. The property is located on the south side of Morris Road, west of Hiram Lithia Springs Road. Staff recommends approval, subject to the following conditions. Number 1, minimum house size to be 1,500 square feet. Number 2, side setbacks to be 5 feet. Number 3, Cobb DOT comments. Number 4, stormwater management comments. Number 5, fire department comments. And number 6, all previous stipulations not in conflict to remain in effect. The applicant is here. Is there anyone here opposed to other business item number 43? Okay, let the record show there's no one opposed, and that completes the consent agenda, Madam Chair and Board.
Thank you. Commissioners, are there any other matters to add to consent? Okay. Yeah, so we do have 2 applicants that are conferring in the hallway. They are, let me see if I see one returning. Good morning, sir. I'm just checking to see if there's been resolve on that other business matter.
Yes, and
Okay, so we'll hear it then, if there. And Can I have someone from staff just go see if the other applicant is, thank you, Sana. See if they're able to come back in. Good morning, sir. Just checking to see if there's been resolve on that matter. Oh, that's the yes, okay, sorry. For the other applicant, Sana, can you let me know who the applicant is? We're just checking to see if we need to hear this matter or if there's been resolve for it to stay on consent.
We don't have a full resolution.
Okay.
You can discuss it and.
Yes, you're still welcome to discuss it during the hearing. And if you come to an agreement, we can still add that back to consent. So, yes.
Yeah, if we just had a couple more minutes.
Okay.
Yeah.
Yes, you have some time.
Okay, yeah.
We can go back to consent even after we approve what is on the consent agenda. We can still add it back during the hearing. Okay. Yes, sir. I'm sorry. Let me have Commissioner Allen state something. Go ahead.
I was going to move to a different.
Okay, excuse me, sir. Yes, this is, sir, can you just come up here to the microphone? I really shouldn't be having discussion out in the aisle. Yes, can you remind me of the other business case you had?
It is OB 31.
Okay,
Yeah. So my neighbor and I have discussed, and we're not in agreement.
okay. So we'll hear this matter.
Okay.
All right, thank you, sir. Okay, John, I have 31, 33 being pulled. Okay,
And I think Commissioner Allen wants to try to add 2 more cases to consent.
okay, we'll take it.
All right, so let me go ahead and call these together. And this is a zoning and a SLUP, so I'm going to call them both together.
Okay,
All right, rezoning case Z26 of 2026, Campus Realty Advisors LLC.
okay,
Request for rezoning from OS to RRC for purpose-built student housing in land lot 363 and 430 of the 16th district. The property is located on the west side of Chastain Center Boulevard, south of Chastain Road. Together with a special land use permit, SLEP 7 of 2026, Campus Realty Advisors LLC, request a special land use permit for purpose-built student housing in land lots 363 and 430 of the 16th district. The property is located on the west side of Chastain Center Boulevard, south of Chastain Road. The applicant is here for both these cases. Is there anyone here opposed to either SLEP 7 or the rezoning case? Z26? Is there anyone here opposed to Z26 or SLUP 7? Madam Chair and Board, there's no one opposed.
okay, thank you.
And John, I'd like to add to the comments on that to that final site plan.
Okay, so first we have a motion on the zoning case.
Okay, and then,
And then do
to
the
add them
SLUPs.
to consent.
Yes,
Okay.
please.
All right, so I move to add Z26 and SLUP 7 to consent.
Okay, do they need to be added separately, or can we go ahead and have a joint motion for both?
I think they could be added separately, but when it comes to the motion of the conditions, they need to be separate. So he needs to stay
Okay,
both
thank
separately.
you. Okay. All right. Is there-
Second.
All right, any discussion? You have a comment, Commissioner Burrow? Go ahead.
I do.
Put your mic.
Have the variances been removed? 80% impervious? and,
Yes, the impervious variance is no longer being asked for. They're going to meet the impervious surface of 70%.
Okay, and what about the Campus Loop Road, Boulevard?
Well, they're still
The
asking for a
access.
variance on the road type because this is not an arterial road or a collector road. It's a commercial logo road.
Okay, and then, since this is on regular and it's other business, there was opposition at the planning commission, so I know they're not here today, but they may be thinking it was gonna be heard. So, I don't know, I'm just asking.
Sorry, Commissioner, I'm not clear. You stated it's on regular, but it was other business?
It's on regular today. We're moving it to consent.
Yes.
But at the planning commission, there was opposition from the Bells Ferry Civic Association. So if they see that it's other business and it's on regular, it's not going to be heard till later. So I don't know if they were coming or not.
Okay, we are moving from regular to consent, not to other business.
No,
Oh, I'm sorry.
Okay.
It's not other business, it's regular. But
Okay,
it's, okay.
yeah,
That's okay.
okay.
okay. You concede, or did you want to? Are you looking for a response?
No.
Okay.
all the motion.
Okay. I don't, yes, if you desired a response, I was going to give the commissioner opportunity to respond. Okay, are there any other questions or comments? All right, call the question. The motion carries 4-1 with Commissioner Burrow in opposition.
Now it's time to do the stipulations for the zoning and then for the slum.
Yeah, it's only for the zoning to, did you add something as well? Okay, to add to the stipulation, the final site plan be approved by district commissioner and reviewed by Kennesaw State.
And you're approving it subject to that and the planning commission?
Correct, and all planning commission recommendations.
Okay.
Is the applicant amenable to those changes? Good morning.
Good morning, Chairwoman and Commissioners. Kevin Moore here on behalf of the applicant. We are agreeable to the additional stipulation. There was a minor change to the Planning Commission recommendation that had been discussed, where we're doing a fence and a tree planted line as opposed to a full buffer against the existing apartments. That was the only change we discussed, that
Is
we'd
that
hope
added
that
as
that
a,
would be
Was that
added.
added into?
No.
do we need to
Do we
add
need
that
to,
as
do
a?
we need to add that
Yes.
10-foot buffer? Okay, so to also strike the 10-foot buffer
Along the west property line?
Along
from the
along
planning
the west
commission's
property line,
comments.
that's
Okay.
correct. To be replaced with fence and a line of planted trees.
Correct.
Clerk is clear? Okay. All right.
So now we need a motion on that one.
Maximum impervious.
It doesn't have anything to do with the impervious.
Yeah, they're meeting the impervious now,
Right.
70%.
Well, the book says 8. Okay, go ahead. It's okay.
Can we just have a clerk's note that there is no longer a variance on impervious? Okay.
And now, so I'd have to do that as a motion?
Yes.
Okay, so the motion is, and I'll do all of it again, to add stipulations to Z26, is that what the motion is for?
Yes.
To remove the 10-foot buffer from the planning commission comments
Correct.
and to add that final site plan is to be approved by district commissioner and reviewed by Kennesaw State University.
And all of the planning commission?
And all of the planning commission comments.
Okay. Got it.
Just for clarification, that also includes the fence. There was a mention about a fence in the planning commission comments.
And the trees, yeah, those are still there.
They're still, okay.
Okay. Any other comments or questions?
I'll second.
All right. Thank you. All right, I'll call the question. Motion carries 3-2 with Commissioners Gambrill and Burrow in opposition.
Okay, now the motion for the special land use permit?
What motion do you
Yeah,
need
what do you
for
need?
it?
If you want to, Commissioner Allen, you just say the same conditions as the rezoning case would apply to this lot.
So yeah, just for SLUP 7, for the same conditions and comments from planning and zoning. No, this is for,
To approve, subject to the same.
yeah, to approve subject to,
The same comments
same
from
comments
the
and-
zoning case, not from the planning commission, because. we
From the
just-
zoning case for Z26?
From Z, yes.
oh, from Z26.
Yes, the same comments that you just had.
You have to do that for the SLUP? Okay.
Yeah.
Oh, because he tied them together. Okay. So to move to approve SLUP 7 with the conditions and comments from planning and zoning for Z26.
Second.
I don't know if that's really that clear. You said the same comments from planning and zoning for Z26, but it's your comments, not necessarily planning and zoning's comments. You just made a minor, you've made some changes. So I would just mirror the conditions from Z26 that were just approved.
Yes.
Okay, so we have to retract your second. So I think she's got it, but so.
There you go.
Move-
They got it.
Yeah, move.
Robin's got it.
Yeah, she's got it. But move to approve SLUP 7, 2026 with the same comments, conditions from planning commission and the commissioner,
Not from planning, the same.
from planning commission, from Z26.
Don't mention the planning commission, just the same conditions from Z26.
From Z26, there we go.
You just approved Z26. Is that clear to you? Is that clear to you?
It is, but I'm not sure.
We did vote on it. We just voted on it.
Robin's got it.
Okay.
We voted to add it to consent.
We did that first. Then we had another motion to add the conditions that you shared.
Okay.
Yeah. That's okay. It's a lot. Yeah. Okay. And there's a second?
Second.
All right. Any further discussion? Call the question. The motion carries 3-2 with Commissioners Burl and Gamble in opposition. Okay. Are there any other matters to add to consent, Commissioners? Okay, I see your hands. Sir, you can approach, please.
We're readdressing the one that went outside. Is that okay?
Yes, sir.
My name's Stuart Knapshin. I'm representing JP Group.
I'm Candace Giuliano. I represent adjacent lot.
Okay.
So Candace is at 540 Harris Court. She was in opposition to OB 33-2026. Our conversation has a resolution. We've agreed to put an 8-foot privacy fence between the two houses to add privacy plantings that would be appropriate between the two houses, retain trees outside of the footprint as appropriate, and deal with rainwater mitigation as appropriate between the two properties.
Okay, I'll turn it over to the Commissioner to respond.
With respect to the privacy fence between the two properties, John, we should have a more concrete location, like along the eastern property line, or would it be sufficient to just include between the two properties?
I think we can just say along the eastern property line, but if she can give us an address of the property the fence goes along, we can add
Yeah,
that to the
she's
record.
at 540 Harris Court,
That's to the north.
and we're on Woods Lane.
Okay.
Okay, she's at 540?
Yes.
Okay,
So that would be the southern property line?
yeah, so that'd be the northern property line.
It-
And that would be a variance, Commissioner Sheffield, because the maximum, it technically is a side yard of your lot, so it would be a variance from 6 feet to 8 feet for the fence.
Okay.
Would we need to apply for a separate variance, or is that appropriate now?
No, the board can approve it.
Thank you.
Okay. And with privacy planting, I mean, that can be a bit subjective. I'm just trying to figure out what the thought is. Is it
Something like an-
evergreens or?
Yeah, something like an arborvitae, something that's kind of bushy and gets tall.
Yeah, you can prove the landscape.
Yeah, I will. I just wanted to know what the thought was, so, I'll know that in advance of consideration, but, okay.
Sort of depends on if there's deer. Deer kind of like one and kind of don't like another.
Okay. Was that all for our consideration?
Right, so just to reiterate, the 8-foot privacy fence, plantings, retain the trees outside of the footprint of the house as appropriate, deal with rainwater mitigation between the two lots as appropriate.
Okay. Rainwater. Okay. Okay, thank you.
Thank you.
Okay, thank you.
Commissioner Commissioner, when you're ready, you can make a motion to add it back to consent.
Yeah, I was just about to ask John if he needed to read or anything, or if I can just add it back to consent.
Just add it back to consent with the conditions that you want to put
Okay.
on the property, Commissioner.
All right, I make a motion to add OB 33-2026 back to the consent agenda with the following conditions. To approve a 8-foot fence along the northern property line between properties 540 Harris Court and the subject property. Landscape to be approved by the district commissioner. Retain trees as appropriate on the subject property, and maintain rainwater between properties as appropriate. And I think that was it, and all other staff comments and recommendations not otherwise in conflict.
Second.
Okay, is there any discussion? Go ahead, Commissioner.
Commissioner Sheffield, I find your motion a little conflicting, because if we look at the site, it already appears heavily treed and landscaped. So my concern is if we have them put in a fence, they're going to have to take out the trees in order to put in the fence. And then we're going to have them replant.
Well, it's not that it's conflicting. This is the agreement that they made, and I believe the motion was to retain trees as appropriate. So the assumption there is, I'm assuming, is they will remove whatever trees are appropriate to install the fence and leave the others. There was no motion to add additional trees or to replace trees. It's to maintain what's there, but still add the fence.
Okay, and then as to your rainwater, do we know if there's a drainage or an easement on this property that is supposed to allow water to flow through? And I guess, to what extent are they going to be responsible for this?
Well, that will be between neighbors, and I will rely on stormwater comments who weighed in on this application as well. But any additional maintenance would be an agreement between the homeowners.
I just have one semantic comment with respect to that. I think your comment said to maintain rainwater, and I just thought maybe it's to address rainwater instead of maintaining it.
That was in my motion or just
In your
now?
motion.
Okay.
Before, yeah.
Okay.
It was in your motion.
Okay.
It's clear
Okay.
what you meant, but it's
Okay,
just.
just change it to
yeah,
maintain.
To address it. You don't necessarily want to maintain rainwater, but you want it to be addressed as, you stated, as fitting
Addre-
between the,
Okay.
as determined between the homeowners.
Okay, thank you. So clerk, I'll go back and change that to address rainwater issues between the two properties as appropriate. Thank you.
You're welcome.
Thank you.
Are there any other comments or questions? Okay, we'll call the question. The motion carries 5-0 to add that back to consent. Are there any other matters to be added to consent? So we took care of other business 33, so the only changes I'm showing, John, is to remove other business 31 from consent and to add Z26 and SLUP 7.
Correct.
To consent. Okay. All right, Commissioners, with that, I move that we approve the consent agenda as it has been revised, recognizing again that other business 31 has been removed from the consent agenda, and Z26 and SLUP 7 have been added to the consent agenda.
Second.
Is there any additional discussion? Yes, Commissioner Burrow?
I'm still opposed to Z26 and SLUP 7.
Okay, thank you. Our clerk can please note that. Thank you. Any other comments? Commissioner Gamble?
And I am also opposed to Z22. Okay, thank you.
Okay, any other comments or questions? We'll call the question. The motion carries 5-0. For any of you who are here as a part of that consent agenda, you are free to leave at this time, except for those that were here with respect to other business 31. That matter will be heard as part of today's regular hearing. Also, for those who are here as part of Z26 and SLUP 7 for Campus Realty, please note that we just approved that on the consent agenda, and that will not be heard during the rest of the hearing today. Thank you all for being here. Excuse me, I need to take a quick 5-minute recess. Clarification. Yes, sir. Hello, and welcome back to today's Cobb County Board of Commissioners zoning hearing this July 21st, 2026. We have concluded our consent agenda, and I will turn things over to John Peterson to walk us through the rest of today's agenda.
And thank you, Madam Chair. Next case on the agenda is rezoning case Z12 of 2026. Dennis Tidwell requests a rezoning from R20 to RM12 for townhomes in land lot 870 of the 16th District. The property is located on the west side of Bills Ferry Road, north of Adair Drive. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to rezoning case Z12? Okay, let the record show there's no one opposed. Would the applicant please come forward and be sworn in?
You can begin whenever you're ready.
Good morning, Commissioners. We're back today to ask you to support this workforce housing proposal. And I want to start with something really important. The community is behind this, not quietly, not reluctantly, fully behind it. We have support letters from the Village at Kendrick Farm HOA, the Delacour HOA, and most importantly, the Cottages of Marietta. The neighbors who have lived with the problems on these vacant parcels for more than a decade. They dealt with trespassing, unsafe activities, constant disturbances. They're supporting our owner-occupied RM12 workforce housing plan because they see it as a real permanent solution that finally stabilizes these lots. We also have full support from A Better Cobb, a countywide advocacy group that constantly backs attainable housing and missing middle formats. Their membership reflects a growing countywide understanding that attainable housing isn't optional. It's essential for Cobb's workforce and economy. I'd like to submit their letter to the clerk. Now, every member of this board voted to adopt the 2040 Comprehensive Plan and the future land use map and the most recent updates. Those documents make several things very clear. Attainable housing is a priority. Cobb County needs diverse housing ecosystem. Housing should be near jobs and services. RM12 is the correct transitional density between commercial corridors and single-family neighborhoods. Our application, Z12 2026, checks every one of those boxes. So it's been surprising to see the hesitation around a project that not only fits the CDP and the future land use map, but also has full community support. That is rare for higher density proposals. At the last hearing, there were questions about what workforce housing really means and whether a developer can be trusted to deliver it. So we addressed that directly. We submitted a voluntary deed restriction requiring all homes to be sold at or below 120% AMI for 5 years. Because it's voluntary, it's legal. Because it's recorded with the county clerk, it's enforceable, just like any other covenant. And it doesn't create any new administrative burden for the county staff. It is in the record today and ready for the county's attorney's review. Then we had a 30-day hold to explore a compromise. In that meeting, we were asked to consider dropping to RM8, referencing Z2 2026 case and broader concerns about keeping densities lower. Even in areas where RM12 is fully supported by the county's own adopted plans. That suggests that an informal density preference, not actual policy, was shaping this review. We explained that RM8 simply doesn't work. It makes workforce housing financially impossible. RM12 is the only density that can absorb the substantial DOT required infrastructure costs. To be fair, there was an effort to explore public funding, curb and gutter, sidewalks, and deceleration lane impact fee offsets. to try to make RM8 viable, but those funds couldn't be secured. Which brings us to the bigger question. Why would the county spend over $300,000 of taxpayers' money to reduce a project from 15 attainable homes to 10? Especially when the RM12 plan privately funds all improvements and still delivers workforce housing the county says it desperately needs. This informal density cap is a political preference, not a legal standard. It's being applied instead of the CDP and the future land use map and the zoning ordinance. The so-called density adjacent rule isn't written anywhere. It's not adopted, it's not authorized, it's arbitrary. And it substitutes personal preference for the county's actual land use policy. After the last hearing, I looked more closely at the Dixon Road project, and what I found was concerning. That parcel isn't even in the CAC. Its future land use designation is IC, industrial compatible. That category is meant for light industrial and employment uses. It does not support residential development. Yet RM8 was used with extreme variances to create another luxury single-family neighborhood. That project doesn't match the CDP, the future land use map, and yet is being used as a model for what our workforce housing proposal should become. Our proposal is exactly what RM12 is designed for, workforce housing townhomes, no extreme variances, future land use map alignment, and the fully consistent with the CDP and the HUD AFFH requirements. And here's one important fact in this entire case. RM8 and RM12 produce the exact same physical development. Everything is identical. Building height, identical. Setbacks and buffers, identical. Parking, lighting, impervious limits, identical. Floodplain, wetlands, stormwater rules, identical. There is zero compatibility difference between RM8 and RM12. The only difference is how many families can live inside the same building form. Reducing density doesn't change the building. It only affects the people who can afford to live there. Workforce housing carries protective status under the federal fair housing law. Cobb County signs an AFFH certification every year and receives millions in HUD funding. Those certifications require the county to identify barriers to obtainable housing, remove those barriers, ensure zoning decisions don't undermine fair housing goals. HUD defines exclusionary zoning as zoning or land use policy that restrict density, limits housing choice, or impose requirements that disproportionately exclude moderate income households. If this board has no objections to height, setback, buffers, building form, infrastructure impact, and the only objection is density, and density suppression is exactly what determines whether homes can be priced at workforce families. Restricting density to price out moderate income households is the textbook definition of exclusionary zoning. The county routinely approves RM12 for luxury developments. That's easy. There's no federal duty to remove barriers for luxury homes. You can apply barriers to it. Workforce housing is different. Once the county signs this AFFH certification, it must remove barriers, not create them. And there are consequences. Westchester County, New York entered a $62 million settlement after HUD found exclusionary zoning patterns, similar to what we're doing. Other municipalities have faced funding freezes and corrective actions. When you looked at the federal guidelines, density suppression on projects that meet all physical criteria is a classic definition of exclusionary zoning. Approving RM12 protects, or approving Z12 protects federal funding, honors the 2040 plan, and delivers a project that the neighbors actually want. This application is ideal for compliance. Full community support, significant infrastructure costs already absorbed by the developer, underground detention, DOT right-of-way dedication, curb, gutter, sidewalks, deceleration rate, full impact fees. These improvements are only feasible under RM12. Dropping it to RM8 would kill financial feasibility, eliminate workforce pricing, kill a project that the community wants, create a clear exclusionary zoning liability. Z12 aligns with Cobb County's adopted plans, stated priorities, and federal obligations. Approving it shows that Cobb County honors its commitment to the AFFH certifications, removes barriers to obtainable housing, supports the missing middle format, rejects exclusionary zoning. You have a legal, ethical, and community responsibility to support this application. I respectfully ask for you to approve Z12 2026. Thank you.
Thank you, sir. Was there anyone here in opposition to this application? Okay, not seeing any, I'll turn it over to the district commissioner.
Thank you, Madam Chair. And we've continued this, so I think we've discussed last time in quite detail, and I do appreciate the communication sense to try and come to some type of way to make this work, because there are a couple of things that I do agree with. One, this is a parcel that needs to be redeveloped for all the reasons you stated, some that I've heard, directly from residents who live in some of the areas. But I want to be clear and make sure that there's that you don't misinterpret what I'm saying this time. This is not about affordable housing, okay? This is about density and location and infrastructure and what this lot can accommodate. And that's been the thrust of the conversations about lowering the number of units that are on the parcel. So I understand the desire, and I appreciate the desire for the affordable housing and to make sure that we're building more of that in Cobb, but it has to be, in my opinion, in the right place for that to occur. So I'm not sure if my other colleagues have comments they'd like to make, but before we do the discussion, I'd like to open up for a motion. And I would move to deny Z12 without prejudice, which would allow you to come back sooner than if it was a straight denial to continue to work. But under its current format, I would move to deny outright, deny without prejudice.
Second.
Okay, is there any further discussion? All right, we'll call the question. The motion carries 4-1 with Chairwoman Cupid in opposition.
Okay, the next case we're going to hear is in our other business agenda. That would be other business item number 13 of 2026, which is to consider a site plan and stipulation amendment for Creative World Schools Franchising Company, Inc., regarding rezoning application Z121 of 1995. The property is located at the northeast corner of Stylesboro Road and Dennis Kent Lane in land lot 224 of the 20th District. Is the applicant present? The applicant is here. Is there anyone here opposed to other business item number 13? We have 2 opposed. Okay, all those who would like to address the board either for or against, please come forward to be sworn in.
Morning. Thanks for your time today. My name is Bob Slaughter. I am with Creative World Schools, Inc. I handle the franchise development, real estate site selection, and work with partners like Amon here to help them secure a site like this Stylesboro Road site that's in question today. So we're hoping to seek your approval to move to the next step.
Thank you, Bob. Thank you again for having me here today. Appreciate the commission's efforts to hear hear our application. And thank you to some of you that have met prior to this hearing to kind of hear what we had to say. So in the last hearing for our school, there was a few items that were brought to our attention that we needed to go back to kind of address. And from what we've done since that time, I just wanted to recap that. The first open item that we wanted to take back for us to come, why we're here today with this hearing is, first was, are there too many schools in the area? The second was the distance between a neighboring community. And the third takeaway that we took back was to get an additional traffic study done to amend our then traffic study. Since that time, I'll speak. I know a lot of questions will probably circle around the traffic, so I won't spend too much time. We have our civil engineer here as well as our traffic engineer here as well that will be able to answer, I'm sure, a lot of questions about traffic. But from the first point, after even when we were doing our analysis, that we believe that our school will be an attribute to this community, to Cobb County. There's different levels of school, from daycares to true educational centers. And in our estimation, there's approximately 6 to 7 true educational, early educational centers in Cobb County. So we do think there's a vast need for this, especially because Cobb County continues to grow and expand. There's logic would dictate that more educational centers, true educational centers for early education are necessary. It's no different than you have cars that sell at a used car lot, and you have cars that sell at premium or higher level types of that nature. So we do think that our school, when it comes to fruition, will serve an unserved, definitely underserved segment for parents that are looking for alternatives of just having their kids their children be just watched and actually truly obtain an education. The second point from the takeaway from our last hearing was the distance related to a neighboring community. This location on Dennis Kemp and Stylesboro Road is very well developed. This is, from my estimation, as you can see from the map, very well developed around, and that neighboring community to which there was opposition, and I believe they're here today. Our understanding is that typically a buffer of 15 feet of undisturbed land is typically required or typically approved. We have nearly 400 feet of undisturbed buffer, including a stream buffer between us and the neighboring community. I think there was concerns about children, small children, creating too much noise, is from what my recollection from the last hearing, and we just believe that that's not really going to be an issue. Again, you can see that there's massive development. There's a YMCA just to the north of where our site sits that's very close to that neighborhood. And again, our school would sit at that that left front corner there for the most part, and there's an extreme amount of buffer, including like I said, nearly 400 feet. And then on the traffic issue, the last time we had the hearing, the ask there was from staff was that we get an additional analysis done. There's a Zaxby's that sits right across the street from our site, and whether there's going to be some type of interactions between traffic coming out of our site and potentially lining up access roads. We've done that additional analysis, and that, which we have our traffic engineer here today, has indicated that that's not going to be much of an issue, or not an issue. We've had several communications with Cobb DOT, and while they don't necessarily, I don't understand that they don't give a recommendation, but what they've enlightened us on is this intersection is going to need a traffic light at some point, probably sooner than later. They've recommended that if the applicant, us, contribute towards that, and you know, just from our viewpoint, is to be a good neighbor, to be a good citizen in this community. We're willing to do that. We think we've addressed all of the traffic concerns, and we think that by our site coming here, us contributing towards the traffic light that's inevitable, it'll be on a faster track to make this overall location a much safer and a better intersection. Thank you.
Thank you, sir. There are 4 minutes remaining on the clock for those in support of this application. If there's anyone else that would like to speak towards it.
Thank you, Commissioners. Robert with Rask Civil Engineering. Covered many of the details that were brought up last time around, but I just wanted to make myself available for any additional questions, detailed or otherwise. And again, as he said, our traffic engineer, as well as Mr. Collins from Cobb DOT, of course, is here to answer specifics that were agreed upon from that traffic study.
Thank you. There's a balance of about 3.5 minutes if there's anyone else. Okay, thank you. Was there anyone here in opposition to this application? Yes. You'll have a total of 10 minutes to address this. Well, I'm sorry. We should have like a red piece of tape there to get people to see that better. Yes, ma'am. You can begin whenever you're ready. Just state your name for us, please.
Thank you for listening to us, and we appreciate this opportunity.
Thank you.
I'm Winnell Jackson Ian, resident, longtime resident, lived in Cobb County at this residence for 25 years, raising family.
It's a long time. If you can help us and just speak a little bit closer to the mic.
Okay.
There you
Is
go.
that better?
Yes, ma'am.
Facts are stubborn things, and whatever may be our wishes, our inclination, or the dictates of our passion, they cannot alter the state of facts and evidence. The proposed site to be developed outdoor playgrounds does not address noise abatement structures necessary to operate below Cobb County's noise ordinance. Our adjacent property is 221 feet away and at the same elevation, 960 to 970 of this site. And once cleared for development, there's no diminishing noise effect offered by the trees or undergrowth located on steep slopes on both sides of the streams. Noise waves have a direct, unobstructed path going throughout Kentwater subdivision. Fortunately, there's already a working model, a workable model. The neighboring YMCA on Dennis Kemp, where noise impacts were addressed through design, operation, and boundary treatment. A 30-foot plus barrier of a continuous 8 to 10 foot high berm, 3-to-1 slope with vegetative cover, surrounds and contains high noise areas. They have operated within these measures, mitigating noise to Kentwater residents and others since 2005. Therefore, similar mitigation is feasible. Therefore, we are asking for a continuous 8-foot berm with a 3-to-1 slope surrounding the playground, extending down to the parking entrance. The berm should be supported by an appropriate masonry structure to maintain the integrity of the berm, not creating additional runoff concerns. A maintenance retainer and upkeep requirements for the berm should be decided by the BOC and attached to the deed for the land. We would kindly ask the BOC to take a deep dive to understand the topography of what is actually on the proposed site, the land's current and structural integrity, and its ability to support the structures proposed on the plan submitted by CWS. In addition, how any changes made to the support the infrastructure play out and impact the area years from now. A submitted site plan was created upon a boundary and topographical survey provided by Belinito, and Associates, which was revised 8207. 19 years of additional uncontrolled erosion of the land composed of Loisburg stony sandy loam with slopes 15 to 45%, resulting in high rates of runoff, sheet flow that has developed gullies, rills, ditches in the land, creating greater sediment runoff, leading to the current questionable stability of a site to safely support the proposed infrastructures for playgrounds. The packet includes the 207 site plan showing the 3 playgrounds extending into the slope areas and recent topographical measurements, as well as current pictures showing the extent of the drop-off of the slopes in each of the area extension. Also pictures of heavy sediment runoff from the land. The area adjacent to the driveway on Dennis Kemp drops off significantly, 20 to 30 feet, a major safety concern. The description given by local residents is, this lot is a big hole with a small peninsula which fronts Stylesboro and Dennis Kemp Lane. As shown on the 2007 site plan, with initial projection of 150 students, the buildings, playground, and parking lot are landlocked. The noise mitigation structure will add an additional 30 feet, continuously surrounding all noise-producing areas. These are additional facts demonstrating substantial obstacles. With the challenges of supporting, stabilizing, or backfilling these overextended areas, we must remind you of the impact of changes to the land, which changes the velocity of the water, increasing the sediment runoff into the 2 streams, which flow into Kentwater Lake, and the increased sediment, which will lead to overflow conditions in the 1% annual flood hazard zone, which directly impacts flood insurance premiums for the area homeowners. The flow continues into the Allatoona Creek FEMA regulatory floodplain. There is a picture of the conditions of Allatoona Creek and Stylesboro Road in June. The question is, and facts are, what benefit does CWS bring to the area that's well-established and is saturated with child care services? And in the next 5 years, we'll see a significant shift to a 65 and older homeowners. According to the Cobb County 2050 Comprehensive Plan, Cobb is trending older. Homeowners' trends are 65 and older, dinks with an average size of family only 3.1. The growth of the town center KSU mentioned by the applicant was given as a reason to support the need for additional child care services in our area. He is correct regarding town center. KSU is one of the projected growth centers for Cobb. But according to the comprehensive plan, new residential growth will be limited and strategic, focused in and around activity centers in the downtown areas of the city. The facts we would like to see are necessary engineering data to support the stormwater plan and acoustical mitigation plan. Steps are necessary to show how this day-to-day operation would seamlessly fit and add value to our community and long-term residents. We respectfully ask the board to review the facts and see if they support the safety and the actual need for this case. Thank you very much.
Thank you, ma'am. Are there any other speakers in opposition? Okay. Not hearing any. John, I'll ask you what staff's recommendation is.
Madam Chair and Board, the staff would recommend the board deny the request.
Okay, thank you. I'll turn it over to the commissioner.
Okay, I'd like to make a motion that we deny OB 13 of 2026.
Okay. Is there a second?
Second.
Okay.
With or without prejudice?
There's a question if you're denying with or without prejudice, Commissioner.
My understanding is they do not own this property. So I guess John or Debbie, how would that impact the property owner since the applicant does not own the property if it's denied?
If
Do
this
we
is-
need to attach it with or without
If
prejudice?
this is denied, then they can't come back for any zoning action for 12 months.
Okay,
If you do it without prejudice, that removes a 6-month period, but we're still subject to state law that requires a 6-month prejudice period.
okay. Then I would be willing to add without prejudice to that, to my motion.
Thank you. Commissioner Sheffield?
I just want a little bit more information from John for the basis of staff's denial.
Yes, ma'am. And, this first came up in May, and at that time, staff did a denial rec also. And the main reason why I did a denial is because I'm still concerned about the traffic flow. This intersection, this area gets highly congested at certain times of the day. And I feel like a lower intensity use would help with traffic flow and prevent traffic accidents at the intersection.
Was that opinion before the agreement to install the traffic signal?
Yes.
And would that help mitigate?
I'm not sure if it will help mitigate it, because what you're going to have then are cars potentially backing up because the traffic signal is on red at one of the points. So I'm not sure if a traffic signal would work out here.
Okay. May I call DOT? I just need clarification on that. It's DOT.
Wilson Collins, Cobb
Hi.
Department of Transportation.
Okay, thank you. Just wanted your opinion on the light. I believe there is a right turn lane off Styleboro onto Dennis Kemp, so I'm not sure how much of the traffic signal would help to mitigate in that area. So if you would just kind of just walk us through that a little bit.
Sure. The larger amount of congestion was actually southbound, which would be leaving the facility and turning left, trying to get back on a Stylesboro Road. The projected difference of delay goes from about 49 seconds to about 112 seconds going southbound without that light installed. I have not seen how that might be modified with the light at this point, but that was recommended in our traffic studies to try and alleviate that failing level of service, Commissioner.
Mm-hmm. Okay, all right. And on Dennis Kemp, I don't think on the site plan there was a decel lane that was included as I reviewed this. Was there a way to kind of mitigate or not allow traffic to stack on Dennis Kemp?
The recommendation is for them to improve the taper and radius curve to try and get a little bit better turning radius going into the facility, not a full decel lane with the contours being so challenging in the area.
Okay. So extending the radius recommendation, that would help to prevent any stacking on Dennis Kemp?
It would help with vehicle movement.
Okay.
Yes,
All right.
Commissioner.
All right. Thank you. Thanks for clearing that up.
Okay, are there any other comments?
On the application, because we talked about the intensity, how many students, because I think I saw two different numbers on here, how many students are proposed at this location?
And I'll defer
I
to the
understand.
applicant on that, because the number has moved up and down a little bit.
Yeah.
So I'll defer to the applicant on
Okay.
the final number.
If
Okay,
the applicant,
I'm sorry, go ahead.
yeah, if the applicant can approach just to answer that question. Because I know the preliminary information, you know, a lot can change between then.
I'm sorry, I didn't hear the question. So.
No, that's okay. What are the max number of students you plan to have at the location?
So this school will be much like the Vining School in Cobb County, which will be licensed for 170 students approximately. And I think the key here as it relates to intensity, unlike an elementary school
No, we
or a
can't.
middle school.
Pardon the interruption at this
Oh,
point. It's
okay.
just asking.
Sorry.
No, that's okay. So 170 students would be your max at this location? Okay. I think I also read that it will not be drop-off, there'll be parking and bringing the students inside. Is that correct?
Yeah, correct. That was what I was getting to a moment ago. I
Okay.
don't know if you want me to elaborate or
No.
not.
no,
Okay,
no,
cool.
no. At this point, it's just whatever questions the commissioners
Yes.
have. Okay. All right. That was all I had for the applicant.
Okay, are there any other comments or questions? Okay. For Commissioner Gamble, was traffic the only consideration for your denial, or were there other factors?
Traffic and intensity of the location. And Drew is not here, but he and I had extensive conversations regarding this traffic study, because while it was done, DOT is not recommending it to be implemented. And part of the reason it's not going to be implemented, if we could kind of zoom out on the area so we could see it a little bit better, great, thank you, is there are a bunch of low-rise office and uses here. And part of the concern is if we put a light here, it is going to make it then difficult for the rest of the traffic to then flow and make it, specifically a left turn is where it gets dangerous, because the light, of course, is going to continue to back it up. My other concern is it's now setting precedents for applicants to think if they just put money towards a light, then they can increase their intensity. I'm having that happen on my Z27, which you can see on this going forward. So to me, a light doesn't solve intensity issues. Yes, we do know we have a traffic issue in here, but a light necessarily isn't going to resolve all the left turn challenges that are faced throughout this entire corridor.
Well, with respect to the light and precedents, you know, we have addressed that issue with several developments, and I know certainly in District 4. So I'm not very concerned about the precedents and applicants feeling that that's the solution, the spaghetti to throw on the wall. I think that each application is different. Obviously, the traffic components are different depending on the area. So I'm not really concerned about the precedent setting, but just to walk through the issues you mentioned with the left turn lane. So you mentioned that turning left onto Stylesboro would be an issue with the LRO development to the south?
So it was actually the LRO. It's actually a real estate firm that is across the street that put in the request for the traffic study, because essentially their clients trying to leave the building or from their facility, their low-rise office, were having a difficult time making a left turn. But making left turns is challenging along this whole corridor. Part of it is, and again, pictures are flat. There is a slight hill to Stylesboro going down, which means you've got traffic flowing to the east that's going downhill. You've got traffic going to the west that is coming uphill. There is some limited site issues that we've had complaints on recently that DOT is addressing at this intersection to help get that visual back. But left turns throughout this whole corridor is a challenge. And it's not just at Dennis Kemp. Which is why, if you look, it's all low-rise, which is our low-intensity uses, which is why, going back to this application, we felt it was too intense of a challenge. We did speak with the applicant and suggested limiting the students to 75 to make it more low intensity. They were not open to that suggestion. Therefore, staff's recommendation of denial is where I'm supporting.
Right, but there's also NRC, which is a little bit more intense. I believe that there is a Zaxby's across the street is what was shared in
And
the
again,
testimony.
doing a left turn there is challenging as well. And if you put a light at Dennis Kemp, you're going to back that traffic up, which is going to make it difficult for people to then make the left to get into the traffic to then flow, or they're going to start stacking in the turn lane, then trying to merge in. So again, lefts are challenging in this area overall.
Right, but just in speaking of the intensity with the Zaxby's, which is right across the street, I mean, I don't know what the traffic count is or the car count is at Zaxby's, but I would imagine that use is also very intense, and that's probably all-day activity, or at least for the most part, but, okay.
Yeah, I'm having similar thoughts to what you're sharing, Commissioner, and just looking at the development all along Stylesboro Road and having questions about what are all of the other uses. They stated there was a Zaxby's right across, but there's NRC that's proximate to this site. I'm not aware of the other LRO uses. Can we zoom out a little bit on this map? But you see much more intense uses all along Stylesboro, and in looking at the 1998 application for a prominent health care center, I'm unsure what the expected traffic is for that type of site versus a daycare center, but certainly commercial was considered at some point in time. And it's unlikely that traffic will be addressed without an impetus to address it. And we've talked a lot about how traffic tends to follow development, or traffic improvements tend to follow development uses. And here you have an applicant willing to come to the table to help address what those traffic considerations are and put in a commercial use that at least is, it will require another business item, but is still a contemplated commercial zoning use within the NRC code. It just doesn't, the prior stipulations require the specification of the use. But one of the main concerns I heard from the adjoining resident was noise, not traffic. And so I was looking at some consideration for how that can be considered. When I look at Landfall Pass, which is one of the closer residential areas, at least is the closest one on that side of Stylesboro, perhaps there could have been some consideration for addressing noise. But to see this being held up because of traffic, when you have a applicant who's willing to come to the table and address traffic, is a concern to me. And I can't perceive that we would constrain the use of this site to something which never came into fruition from 1998, that there has to be some progression of thought as to what could be done here at this site without constraining it to a prior use and making it more limiting than the other uses that are proximate when I'm looking at other intense commercial uses along the street. And if those things were of such great concern, I'm not perceiving why there was not action to address the traffic to me, an application like this is an impetus to finally address the traffic. And you're doing it by mitigating the cost of that to the county in partnership with the applicant, which I think would not only be beneficial to them, but beneficial to the existing users or drivers along that roadway and other commercial uses. So I'm just less inclined to want to deny this based on traffic. I would love to see consideration for the concerns brought up by the resident that spoke in opposition, again, with the greatest concern being noise. Are there any other comments or questions? Okay, not hearing any, we'll call the question. The motion does not move forward with Commissioners Sheffield, Cupid, and Allen in opposition. So we'll have to have another motion.
Okay, then I will put forth another motion.
Okay.
That we approve OB 31 for a maximum, or
13.
thank you. OB 13 for a maximum of 75 students. The site shall require a 10-foot berm that shall be completely landscaped and maintained to address noise mitigation. The applicant shall be required, because if you look at the DOT comments, it says to recommend the applicant consider entering into. So in order to gain the benefit of the light, they shall be required to contribute 10% of the estimated $75,000, or I'm sorry, they shall be required to contribute $75,000 to an escrow account for a future signalization of this intersection. The district commissioner to approve site plan and landscaping and signage. And then it will be subject to all Cobb County DOT or Cobb County staff comments and recommendations. And if any conflicts arise, it must come back as an other business item.
Okay, is there a second on that motion?
I'll second in discussion.
All right. Okay, we have a second. We'll go ahead and begin discussion. Commissioner Burrow, since you have the second, did you want to?
Okay.
Sure.
And are you going to specify that this is a walk-up, no drive-through plan?
To me, we're approving a daycare. We can't approve the type of services they recommend. All we can recommend is, are we going to allow a building there and how much parking? We can't mandate that they drop the kids off or if they mandate them walking in, which is another reason for the denial, because that is not something the county can oversee. So while they're telling us they're going to have a walk-in model where cars are going to park, there is nothing to prevent a daycare going in there and then it turning into a drop-off model only. And there is no queuing plan, there is no stacking plan, which again is then going to back traffic up and potentially cause more infrastructure issues at this corner.
Okay. Are there any other comments?
I just wanted to address the maximum of 75 students. And I also want to share that with the daycare, unlike a school, there are different drop-off points or different drop-off times potentially, as well as different pickup times. So there may not be, a huge number to drop off at one time. And also for consideration, there may be multiple students that belong to one family that may be dropped off. But it goes back also, I want to address the proposed medical center that was approved at this location. I don't know the particulars of the medical center. I don't know what the capacity, how many practices would have been in the building, but it's likely that it would have been more than 75 vehicles at the medical center, possibly at any given time. So I'm not supportive of restricting to 75 students.
Well, and if you go back and look at the site plan that was originally approved, that was for the medical center, this entire corner has not been developed per the original site plan. It is completely different. So the original site plan might have planned for this, but then over time, it has shifted and changed. It was never intended to be this intensely developed with the number of different businesses. Because if you look at the site plan, essentially you had the office building, you had tract 1, there was a road, there was interparcel connectivity. So there's a lot of things that have changed since the original 2007 approval.
Right.
Or actually, was it 2007 or was it in the 90s, John?
That was in 95.
95. 95. We've got the library here, we've got the YMCA. That whole front section along Mars Hill at Stylesboro wasn't supposed to be developed, but now we have, it still is a Walgreens, it used to be a bank, now it's Chick-fil-A, it used to be another bank, now it's Starbucks. So again, over time, it has all changed. But also then going down Dennis Kemp, you've got a dentist office that is in here as well, which is a low-intensity use. So going back to a site plan that was changed or originally approved in 2005, but we have deviated from it. Again, to me, this is an intensity issue, which I think can be further supported by the low-rise office that is adjacent to this. And in that low-rise office that is adjacent to this, you've got a pediatrics office and then other small type office services.
Mm-hmm. Yeah, I certainly agree that that the development has changed over the years. But what we do know is that there would be some type of development. Now, whatever the zoning category may have ended up being, it's a different story, but we know that at some point this would have been developed into something. We have the future land use map. I'm not sure how these parcels kind of fit into that, what's been changed over the years in terms of the zoning district. But there definitely would have been some type of development that could have also impacted traffic over the years, even if the medical center was developed.
Okay. Right, but if the medical center had been developed, this whole section would have been different. Again, go back and look at the site plan. Go back and look at the site plan, because you wouldn't have been able to do the Y, you wouldn't have been doing the library and everything else. So there has been a big shift since 1995, if this is when it was first done. And again, I would support a lower intensity use on this parcel, because essentially what they're asking for is the same number of students that some of our private schools have.
Well, I don't know.
So again, it goes back to intensity. It goes back to intensity.
Right, but I don't know that they're asking for the same number as what the private school has? I mean, I don't know. It just could be coincidence, or it just could be for the viability of the business they're asking for that number. I don't know. I hadn't had an opportunity to ask that question.
I can provide you that answer if you'd like, because Dominion Christian High School is anywhere from 170. They're now getting up closer to 200 students. They've got an extensive, ability to move traffic through. Midway Covenant School is a private school. They don't have upward of 170 students. And again, they're able to stack all their cars. They do various drop-offs. But even we cannot control the staggered times that parents drop off or pick up their children. That is not something that we can consider. The question is can the site accommodate the use? And I think what they are proposing is too large and too intense, but if they are willing to do it at a smaller scale, I could support that.
Okay, are there any other comments?
Just is it appropriate to ask the applicant a question at this point, or we just, it's not?
We typically don't, but under these
Well,
circumstances, because
the only
this has
reason,
evolved, I have material questions that I can't approve.
Yeah, well, and
I can't move forward.
I'll start with my comment, and then if I have to ask the question, I'll ask. But, so where I'm torn is there's a creative world in my district on Cumberland Parkway. I believe is where it is in Vinings. And when this originally came a couple of years ago, there was a lot of concerns about intensity, about traffic in there as well. But I think we have not seen any of the fears materialized. And so from a practical standpoint, I'm looking at a similar use and understanding the staggers. And I would contend, if you're looking at that curve that it's on right there on Cumberland Parkway, it's far more challenging than what this is. And it has not been, like I said, none of those concerns that were originally talked about have been realized. So now what I don't know is what are the number of students at the Vinings location compared to the 170 that are going to be, because that could be materially different. If Vinings only has 50 students and this has 170, then that could be, into that. But from just an operational standpoint of seeing this, I've seen it operate well in a far more challenging intersection on a much narrower road with a steep curve right at the entrance, and it has not presented any, if at all, challenges. So just wanted to put that on the record as well. That's my internal struggle with this application.
May the applicant approach so we can just get clarification on the number, please? Good morning.
Yeah, thanks for the additional questions.
Thank you. Can you clarify what your enrollment is in your other location?
Yeah, so it's a licensed capacity of students, and the enrollment at Vinings is 170. They're in summertime at about 140 right now. I don't know that they've ever reached peak in the 3+ years that they've been open, but that would be about where we would hope to be with this school.
Okay, thank you. Appreciate it. We'll
Okay.
call back up if there are any questions. Since we're talking about enrollment, I also have concerns about limiting enrollment, just because when you start impacting enrollment numbers, then that gets to business viability. And we're also asking for them to contribute to a traffic light. So we are constraining their ability to have the resources to contribute to a traffic light without some conversation about how that business model operates based on enrollment. So that would be a question that I have concern about, so that we are not hamstringing them in doing something that we're obligating for them to do. Something I can also share from my experience with 2 school-age children, they're now teenagers, and also living off of Veterans Memorial, which has very large daycares along it. I have never seen traffic backed up in any of the daycares that are huge. off of Veterans Memorial, and there were about 3 clustered together. Also, from the daycares I've sent my children to, never been a traffic issue outside of trying to get into the daycare. And I think part of it is because of the staggered times parents are bringing their children into the daycare. I can't say what it all attributes to that. I can just tell you, just from living close to many large daycares off of a very busy road that would be impacted by that, also by having experience of dropping off children to it, not been an issue. There's sometimes been an issue of the queuing inside daycares when my children went to home-based ones that were very small off of roads. And again, it wasn't a traffic issue. Outside, it was just, particularly as parents are racing towards the end of the day of the picking up of the children, which can be mitigated. I don't know why there's an assertion that's saying that we cannot condition the pickup and drop-off. We can condition it. Now, we have conditions on many applications that could be violated unless somebody from code enforcement is standing right there to see if they are if they are operating consistent to that condition. But to say we can't do it is I think a blanket statement that does not necessarily reflect the other types of conditions that we put on properties. And I do not see anything that bars us from asking them to comport with what has been asserted in their application, which is for their parents to park, or if it's not a parent, whoever is dropping off and picking up that child to park and bring the child in, and to park when they're taking their child off. Not only does that help with traffic, I think that helps with safety of navigating the parking area of the site. And that would be something I would encourage you to put in place, particularly if they are volunteering that that is what they are going to do. And they have to operate with the integrity of knowing that that's something that they've committed to, and perhaps put something in their policies to enforce that with their parents. But again, this is something that they're volunteering, and so I would, if they're willing to put out a stipulation and say that they're going to do it, we have the ability and latitude to be able to put that in place. I'm trying to find the verbiage back. I've been looking at this map. So looking at walk-in, the maximum number of students drop-off. Yeah, those are my 2 main issues. Again, just getting back to my main issue, you can look all in this area from Mars Hill, Dennis Kemp, Stylesboro, see a number of commercial uses, some more intense than as intense as or as broad as GC, NRC to LRO. I'm having a strong difficulty in denying this application for the basis of traffic, but I do appreciate the stipulations provided to help mitigate the issue of noise, which again, noise could be created by a lot of those other commercial uses, but if considering that the noise element was something that was expounded upon heavily by the neighbor and resident, I'm hoping that that's something that the applicant can meet halfway with addressing. And that's something we did not talk to the applicant about, so that's something that I can.
Well, instead of trying to write stipulations and such from the Diaz, I'd like to offer a substitute motion.
Okay.
I'd like to make a motion that we hold OB 13 until the August hearing date, at which time I will also ask Yolissa from Code Enforcement to bring forth the code violations that we've had of other daycares in the area that have caused traffic backups along Stylesboro, just to put that on the record, since that is something that has been addressed. Again, there's There have been complaints from the constituents, so just so the board knows, I will have her bring those back up as well. But give 30 days to work with the applicant to see if we can come up with some agreeable stipulations.
Okay, was there a second for that substitute motion?
Second.
Is there any discussion?
Just on the map, I wanted to see where the opposition lived in relation to this parcel, because the adjacent parcels seem to be all commercial. Can you just put that back up? And also regarding the code enforcement violations, I'm not sure, are you saying that Ulisa has violations because of stacking?
Yes, stacking. So on the south side, there are 2 daycares in these LROs. And they are supposed to have a stacking plan, right, for their vehicles to come in and park. Oftentimes, cars are stacked on Stylesboro Road, trying to get in to pick up, to then circulate and come back out. So there has been several complaints by residents in the area of when those violations occur. So then we have code enforcement go out, essentially see when they observe it. I personally have seen it happen when I'm out in this area. So we do know that the existing daycares that do not have a park, walk your child in, are having issues with moving their traffic and keeping it free from the roadway.
Right, because they're violating a condition, but that condition is not on this application. So I'm
Correct,
just
but
trying
the
to
comment,
connect
the
those
comment
dots.
was made that, you know, it doesn't cause traffic problems, right? That when you've got plans and stuff, that you can mitigate that. Yes, you can have plans, you can try to mitigate it, but what I'm saying is we do have evidence that even though you've got plans, you've got stipulations, it's still happening. That's all I'm putting it on the record for.
I would just, same caution I had last hearing when we had something like this, where one person's infractions doesn't mean someone else is going to have an infraction. So we have to be very, I understand where you're going with that, but just have to be very careful. I think these are uniquely different, that they're in shared spaces with limited parking, whereas this is more of a single use that is, you know, as the chair said, could be stipulated that there is no, you know, carpooling, that it's more drop-off pickup and parking spaces allotted for it. So I would just, you know, caution us on that, not to stack and start to prejudice judgment based on other infractions.
On those lines, I'm always supportive of us taking time to hold things, to have further discussion, and to see what agreement can be worked out to move things forward. But the preface to the request was made in such a prejudicial fashion that it was almost to paint a picture that would cause us to want to not support, or to support something that's constraining. That's what makes me less supportive of the request that was put out there. Again, I am not stating that parking and queuing is not an issue that should be addressed. But what I am stating is, from my observations and experience with large daycares, I have not seen that. And there is also a proposal to help mitigate those issues by having parking on site. So holding it to look at something that is not an apples to apples comparison is not compelling for me. Yes, Commissioner Burrow.
Well, first of all, we look at each case individually and on a case-by-case basis and surrounding. There may not be any traffic problems in Cumberland or Mableton or other East Cobb, wherever, but you're not comparing apples to apples with the size of the parcel and the traffic and the surrounding uses. So how do we know? But I think, well, I would rely more on the district commissioner for her site and her district to know the area best.
Thank you, Commissioner. And yes, there is a lot of deference given to the commissioner. It is just hard for me to overcome what I heard from the resident that lives close by and the issues that she shared of what's going on here at the site. And the predominant issue that colored her remarks had to do with the noise, not with traffic along Stylesboro Road. And I'm not saying that is not an issue. It did not come across as the prevailing issue. And looking at, again, all of the other intense uses along this roadway, I cannot see that being a prevailing issue to bar this use from moving forward, knowing what, or at least with my experience that I've had with daycares, with drop-offs at daycares, with living near large daycares, I cannot perceive barring it based off of those things. But I hear what you're saying. We do look at things on a case-by-case basis. That doesn't mean that we don't look at our experiences and other zonings and other information to help us inform the matter, but they're not necessarily dispositive. We have to look at, again, what is being presented in front of us, and we take all of those things into consideration to come up with a decision. And I'm just not seeing anything that, I'm having trouble, in fact, I'm not seeing anything, I'm having trouble denying this based on the reasons that I've heard here today.
Okay, one other comment, if I may.
Yes, ma'am.
And we may need Wilson to, this is at a level of service D now. And would 170 students change that? I'm sorry. I was looking, I know they did the submittal to traffic study in May.
Wilson Collins, Cobb Department of Transportation. Commissioner, the traffic study was done with the anticipation of 200 students. So that traffic could be revised to see what a lower amount of students would do to the level of services.
But is it still at a D, or does it increase at all with 170 or 100, 200?
With the reduction of 30 students, there's a potential for the level of service to improve. Without seeing those calculations and the simulations, I can't say if it would be enough to justify a better level of service or a reduction of impairment to the level of service.
Okay. Thank you. Okay. All right, so we now still have a substitute motion to hold this until the next zoning hearing. There's been a motion, and I'm sorry, second, yes, further discussion.
Well, I requested that we kind of pinpoint where the opposition is, because I don't want them to get lost in this conversation either. When they mentioned noise, the handout didn't include an address, which was fine. I was just wondering where they were in relation to the
You
parcel.
wanted to know their addresses, the oppositions? I'm sorry, I don't see.
Or if the commissioner knows where their property is.
Hi, Brad McCahill. We're at 1926,
Okay.
and we are in the backside of that cul-de-sac. We are the closest.
Okay.
Okay.
All right.
Thank you.
for that.
Appreciate for sharing that.
And-
Yes, quite
Thank you.
proximate.
Can we comment on one thing?
I'm sorry, you're only able to answer questions provided, but thank you.
Thank you.
They're fairly close. Can I have the applicant please approach, please? Another question with respect to noise. No noise particularly. What noise abatement measures have been considered, and are you also willing to support the noise abatement measures that were put in the commissioner's prior motion?
I'm sorry, could you repeat that?
Yes, what noise abatement measures were considered for this application?
Well, there's a security fence installed around all of the playgrounds and the perimeter of the school, obviously to protect the children. And those are 6 feet tall. I mean, we want to be a good neighbor. We have no problem making that fence larger or creating some other kind of buffer. A 10-foot berm might be a little burdensome. I don't know what that does as setbacks, but yes, I mean, we want to fit into the community. We don't want to disturb the neighbors.
Okay. Okay, thank you. All right, so there's a substitute motion to hold this application that's still before us. Is there any other comments or questions? We had a motion and a second. We'll call the question. The motion carries 4-1 with Chairwoman Cupid in opposition. So this, again, the motion is for this to come back at our next zoning hearing. All right. Next matter.
And before we move on, Madam Chair and Board, for the one we just heard, is there any direction to the applicant on what to look at or what to change?
I would just encourage the applicant to work with the district commissioner. They've heard our conversation, they know what pain points are.
Okay.
Is there anything in particular, Commissioner, you would like to put on the record in terms of direction from the applicant?
She did in her stipulation.
Commissioner Gamble?
Thank you for your support today, Commissioner Burrell. I did bring up several issues.
Okay.
These are the same issues that were brought up in the meeting that I had with the applicant. So they are aware of my concerns, and we are here today. So we will be here in 30 days to see if they've been addressed.
Is there the possibility of a new traffic study just to confirm whether or not it'll have an impact with dropping it to 170 students? Thank you.
Thank you, Commissioner.
Well, a new traffic study won't be required. They'll just make.
I didn't say required, just adjusting the traffic study they have to show if there's
Right.
any material impact to dropping it to.
From the D. Right. And access and turning and all that.
Just
Whatever.
I'm just going to make note what we just heard and observed, because we've just deliberated a matter, and John, you asked if there's anything specific, and what was shared is that I want the applicant to address the same things that occurred or that were discussed prior to this hearing that we just deliberated on. So what this tells me is we're going to end up right back in the same position, which is my concern for us holding this in the first place, is to get us back to where we are here today. You know, there has to be some good faith measure when we hold these applications, because time is money. Time, you know, when people come forward for hearings, they're expecting us to do the work up here. And I'm not saying there aren't reasons to hold it, but there should be some good faith consideration when there's conversation that takes place outside of here, that there will be some discussion and weight to what happens here, or else we're just holding it just to be holding it, which I just find not to be a best business practice, best practice for us as commissioners. So, with that, we're moved on. We can go to the next matter.
Okay. Next case is other business item number 31 of 2026, which is to consider a lot size reduction for required 80,000 square feet to 11,614 square feet for tract 1 and to 8,263 square feet for tract 2, to reduce the required public road frontage from 75 feet to 0 feet for both tracts, and other variances for William Mungie. The property is located on the south side of Old Dallas Road in land lot 30 of the 19th District. The applicant was present, and earlier there was one person here opposed. All those who would like to address the board either for or against other business item number 31, please come forward to be sworn in.
Good morning, Commissioners. My name is Will Munji, and I submitted this application to essentially reverse a lot merger, which is in process, and I was asked by the county to submit a lot size reduction variance and a frontage road reduction variance because the property is not on Old Dallas Road. That was essentially approved by the county, but to get an address, I had to do these two variances and get approval from the commissioners.
Okay.
The objection that my neighbor has is that I might in the future build a house on this property, on the second lot. And there was a house on that lot when I purchased it in 2016. So I don't understand why he would be in opposition to me using property that I pay taxes on. And essentially, that's the opposition that he has, not to the variance applications that I have today, but rather to the use of the property.
Okay. Thank you for clarifying. Does that conclude your presentation, sir?
It does.
Okay, thank you. Is there anyone else to speak in support of this matter? Okay, we'll now hear from opposition. That's 10 minutes. Yes, sir.
Good morning, Madam Chairperson and Commissioners. My name is Jeffrey Cassis, and I own the property at 2085 Old Dallas Road, which is just to the south of Will Mungy's property. That's it right there.
Okay.
And yes, there was a house there before, and it was, I don't know when it was built. It was built before there was zoning, code enforcement, planning commission. None of that existed back then. The square footage of that house was about 400 square feet. And it was not so much a house as it was a cabin or a shack. It was very deteriorated. And when Will acquired the property, he chose to demolish the house and remove everything from the property. And now it's just green space right now. I don't have a problem with Will breaking off this property from 2071, which he purchased earlier. I don't have a problem with that. What I have a problem with is what's going to come later on. Will has mentioned to me that he has interest in building a house on this property, and that property that he's breaking off, I see R80 up there, but the property is only 12,100 square feet, estimation. And another difficulty I have is that my house, the setback from his property line is about 4 feet. I have no setback. Back before there were rules, people could do whatever they wanted to, and that's what this property owner did. He carved out a little piece of property for one of his daughters to move into it, and that's just how things worked out over there. Now, what you can't really see on that drawing right there, I've got a rough sketch right here for y'all to look at. Can you put this on there? Okay. You can see 2085 Old Dallas Road. That's my property, and I drew a little box where the house is. And so the house is real close to that north property line right there. And the water line that I have coming to my house, it runs through Will Mungey's property. And the easement that I have to get to the road, it runs right through that property. So essentially, there's not a lot of room to build a house in the future. So what I'm asking for is that you allow Will Mungey to split this property off like he wants to. However, include a condition that no residential dwelling will be built on this property. I don't know if that's possible. I don't know if that's legal. I don't know if it's okay to build a single-family dwelling on 12,100 square feet. The zoning would definitely have to be changed. But it's a complicated lot. I'm concerned about what's going to happen down the road. I'm fine with Will breaking off the lot. I just don't know what is going to grow out of the ground right there. And the character of the community will be changed, and we don't know what that change might be down the road. So I'm just looking out for the future. And that pretty much covers it.
Okay, thank you, sir.
Thank you.
John, what is staff's recommendation?
Madam Chair and Board, the staff would recommend that the board approve the request, subject to the lot size reductions and the variances as shown on the site plan received May 15, 2026. Fire Department comments and recommendations, Cobb DOT comments and recommendations, and maximum house footprint on Tract 1B, 1,000 square feet.
Okay, I'll turn things over to the district commissioner.
And John, just to help clarify for the rest of the board, because I know you and I had extensive conversation, we're on our screen 2071. That is where the existing house is, correct?
Correct.
And so where it says OB 31, that is where we are going to restrict the future home, if built, to 1,000 square feet, correct?
Correct.
So if that kind of helps the board. Again, John and I had extensive conversations about this because the applicant originally had both lots and then combined it, and now he's essentially asking to undo it. Within the approval, there's also going to be no variances, which means he will have to meet setbacks and such going forward. And impervious. If I could have someone from the water department come up.
And while he's coming up, Commissioner Gambrill, the site plan does show the setbacks on it, so there would have to be a variance for the setbacks because they can't meet R80 setbacks at all on these lots. So if you look at the bottom of the site plan, it's got a front for 30 setback, 10-foot side, 30-foot rear, maximum 50% impervious per lot, which is what it currently is on 2071, and then minimum house size of 800 square feet, which I think is what 2071 is a little bit over 1,000 square feet.
And those setbacks, are those, they're not R20 setbacks, because R20 rear is 35.
No, they're not R20, but the setbacks would match what's currently on the property for 27.
What's currently on the property. Okay. If I recall correctly, prior to the lot split being done, he was going to have to bring sewer to these sites, to these two parcels. Am I correct on that? Because I'm not seeing it in our comments here.
Chris Duggan, Cobb County Water. The county code does require when you subdivide a piece of property and the lot sizes are smaller than 80,000 square feet, you've got to sewer the lots. We do kind of make an exception if a property was 2 lots and then it was combined and then subdivided again. So I don't think we would make him connect to sewer in this case.
Okay, thank you.
So this is zoned R80, but even combined, it's not, it doesn't meet R80.
Correct.
Commissioner
So
Burrow,
why
there's,
wasn't it ever changed before?
Well, these are grandfathered lots, Commissioner Burrow, that have existed prior to zoning. And for instance, the lot to the south that the opposition lives in, the 2085, that one's about 15,000 square feet. And then the one to the north, the 2065, is about 25,000 square feet. So these 4 lots do not meet R80 at all. They're just all grandfathered, tiny lots.
Before we had zoning and code enforcement and all that.
All the good stuff.
and part of this also, Commissioner Burrow, goes back to when Commissioner Gorham was here, and they increased several parcels to R80 to help preserve the rural character of the area. This was one of those areas that had that change done to it, which also made it a lot of non-conforming lots, because we've also got non-conforming lots that are on the other side of the road that is adjacent to Dallas Highway.
Okay. And the track 1 that you're saying is going to be 1,000 square foot dwelling. I see somewhere it says accessory unit, but it doesn't connect to the
Well,
main
on
house.
track 2, there's a little shed next to the house. That's to the front of the house. That's what that accessory structure is.
Oh, okay.
It says building.
Okay. So that'll be a separate house on
That's a
the
shed.
other side. No, I'm talking about the 2 parcels where it's split. To the left is that where it says OB 31, to the left of the red line. That's where the 1,000 square foot dwelling will be. But then on here, there's already a shed attached to the house?
No, the shed is not attached. It's just shown on the site plan as being on the property.
Okay, but this site plan proposed shows a walkway to the house, attached to the house for that shed, or it says building. What is it?
Actually, from the GIS, and we can ask the applicant to come up, and it almost looks like the driveway that then goes back.
It
and-
says walkway, so I'm just,
Right, but if you look, I guess,
May I clarify? So, Will Munji again. If you can switch over to the map, the survey that I submitted to the county.
this.
You're right. So the building that's shown on track 1, I guess, has been demolished. That there, right, is no longer there. And there was a storage container or shed between both properties that's also been removed. So if you look at the date on this survey, it's a few years back, but it was updated recently to comply with recent requirements to submit to the Superior Court. So some of that information is not accurate as of today.
Okay.
so have you submitted a current site plan to the county?
Everything else is correct except for the fact that those have been, and I did indicate when I submitted to the county, those were demolished. So there's no structure, as my neighbor said, there's no structure on the property that we're discussing today.
Right, but I guess the structure that is under question is the one that says BLDG, that used to be between.
No, that's a different property, ma'am. Right, that
No.
one was on my property, which has been demolished.
No, move the hand up. There we go.
Right there.
Right
Okay.
there. That one, is that one still on your property?
No, it's not.
Okay, and so that has been on your,
This is the current site survey of what was there now.
right, so essentially what he is saying that where the hand was, that, yep, that one is not there.
It's just, yeah, it was a storage unit attached to the house, to 2071.
But that is no longer there.
No longer there either. But that's on the separate property, which is not what we're,
So does that help, Commissioner Burrow?
Yeah, that explains that, because I was thinking this is what he's proposing, but you're not proposing anything on,
2071, no. So there's 2071 that has a house, which is to the east. What we're talking about today is track 1, which is to the left or to the west.
and is anything going on there?
No, it's vacant land.
Okay.
It's
But
vacant
in the
land.
future, because that's what the
Right.
opposition's concern was, what would go there?
There
or
was a
What
house,
would be approved to go there?
there was a house on that property when I purchased it, and I paid taxes on this property. Mr. Cassis knew the landowner who sold that property to me and chose not to purchase it. I purchased the property and I took it down because the building was over 50 years old and needed to be demolished. And even though I am going through a lot merger reversal, it doesn't infringe upon my property rights for both properties. On the borders, the boundaries are still intact. I'm just reversing a tax merger. And I don't understand why the use of the property should be dictated when I own it and I pay taxes on it by my neighbor.
Commissioner Burrow, that's part of the reason why in the stipulations that John read into the record was that is about what was there prior to being removed. So we felt that, you know, by stipulating that they could put back essentially what they removed, kind of put in some guardrails. And also knowing that the lot is non-conforming, you know, you're going to have to have variances for setbacks to meet R80, even though we know this isn't R80. But even if we would try to hold them to more of the R20 guidelines, they would still have to have variances in addition to the impervious exceeding the required 35%. But again, this goes back to where the challenge is this was grandfathered. This was, you know, done before zoning came about.
Are there any other comments or questions?
So in the future, if something is built on this lot, would it need to come back to the district commissioner for approval or other business?
As long as they stay within the 1,000 feet guidelines that we're going to propose today for the applicant to follow, I don't see where I need to weigh in as far as the type of house that's built.
Okay, and the applicant's agreeable to keeping that at 1,000-foot lot, structure?
We can ask him that on the record if the applicant can approach.
Was that in there when it was on consent?
Yes, all the conditions that we're discussing were there when this was on consent. So the question, sir, to you is, are you agreeable with the terms that were read for approval of your application, with limiting it to 1,000 square feet for tract 1?
if I have to resign myself to that condition, I will. But I would like to ask the commissioners to tell me if any of my neighbors influenced or requested that that motion be imposed upon me. If the public that I sent out letters to asked for that, I would like for the county to be open and disclose that to me.
So I will respond to that as far as, because there was, again, great discussion on this. So my question to staff was, what was the size of the home there previously? And that is how we came up to the 1,000 feet. Because we all know that a property owner has the right, again, to build a home back. We also know that you should be having to follow certain stipulations as others do. Now, granted, this is a different situation because your homes and your neighbors' homes were built prior to zoning. So there's easements on here, there's different things based on the fact that you had a prior home. Again, knowing that there is now impervious surface, there's now setbacks, there's now other guidelines that you need to follow, we thought a good compromise was to say that you could build back a house of a similar size and structure that had previously been there. And as far as, I will put it on the record, I had no communication with your neighbor prior to today.
So what
Because that was also the reason why this was on consent, is because there was no opposition to this.
So I find myself in a position where we've jumped 2 steps ahead, if I may.
Chair, this is not.
I don't know.
I know we're asking questions of you at this time, so even though you may have questions, because I'm not aware of, well, because you already had your presentation, that was a time for you to be able to provide your presentation of your position. So any questions that we have, you're being asked to just respond to those questions. I understand you do need some clarity. I need some clarity myself. It's perhaps in our deliberation, you may be able to get some additional questions answered.
I was going to
Yeah,
ask
excuse me,
before
sir,
he
before
was
you're
seated.
seated, sir, you do have a question.
If you can return, yeah. Return, yeah.
Yes, please.
I wanted to confirm the square footage of the home that was there previously. I've heard comments regarding the 1,000 would be fair considering what was there before, but I don't know that I had clarity on the square footage of the previous home.
I don't have that exact number right now.
Okay. John, do you know what that square footage was?
Based on the GIS, I was estimating, 600 to 800,
Okay,
based on the 2016 GIS.
okay. All right, thank you.
Was this an older home that was on the property?
Yes, it was built in the 50s.
Okay. So we're going to require him to build a 50 standard size home?
The way the condition is that was on consent is the maximum footprint of the home is 1,000 square feet. So if he wants to build a 2-story home, it could be 2,000 square feet.
Why would we limit him to, why are we limiting the
pad size, basically.
Yes, thank you, that's what I'm looking at, not the height.
Well,
Why are you limiting the height? This is
Not
about
the
setback. I'm hearing that he can have 1,000 square feet as far as the size of the home, irrespective if this is a 1, 2, 3-story home. What does
No,
that?
what he's saying is 1,000 square foot pad size. If he wants to go vertical.
That's not what John said.
Yeah, that's what, yeah.
That is not what he said.
He said, but you can also build up.
But so what you're telling me is that can be accomplished when you build it up. Okay, excuse me. Let me be clear on my interpretation of what you're telling me. My interpretation of what you said is that this can be 1,000 square foot home, irrespective if it's 1, 2, or 3 stories, that's 1,000 square feet.
No, the condition that was on consent was maximum house footprint on tract 1B, 1,000 square feet.
When you say footprint,
So
your
the-
footprint means.
So
the-
if the house is 1,000 square feet, that's it for the footprint, but they can go up one more story and have a 2,000 square foot house,
Okay, thank you.
or up to
The
2,000 square feet.
foundational size.
Okay.
May I clarify just one thing? The reason why there's some limitations here is because this is a grandfathered lot. So the zoning is R80. So he would have a right to build a home on an R80 lot if he could meet all of the setbacks, the various conditions that are in there as R80 now. It's impossible with this such a
With the
small
configuration.
size. So if we didn't put any condition on there at all, just allowed him to undo what he's doing, he would have to come back to this board to build anything on that property because he cannot meet the R80 zoning. If that helps at all.
It does. That is my thought, is that that's what we're providing clarity to.
Correct. So
Okay.
the commissioner's suggestion is that if we give him something now and he can comply with that, then he doesn't have to come back to the board.
Okay.
Otherwise, he would have to come back to the board to do anything on this unconforming, non-conforming lot.
Okay. Yes, and thank you for clarifying that, and that's clear to me. I just thought he was being constrained to just 1,000 square feet, but it just looks as if, as Commissioner Sheffield and Sherry, that's just to the base or the foundation of the home, not to the overall size. Okay. Okay, that's all the questions I had. I'm sorry, were there other questions? Commissioner Sheffield?
Yeah, I just wanted to ask the commissioner, at 1,000 square feet, my only concern there is that it may be a 2-bedroom, 1-bath, just kind of looking at the size of it. And I'm just concerned about the space on the interior. So I don't know if there's consideration to add maybe an additional 100 to 200 square feet, if that would make a difference with respect to the, with the setbacks, et cetera. But it may make a significant difference with for who would live in the home. And I don't know if that's a question for the applicant to kind of confirm the number of bedroom and baths.
Well, and we've kind of already rounded up, right? Because when John said that he went back to 2016 and measured, it was roughly 600 to 800. We, again, GISs. So by going up to 1,000, we've already given him a benefit there. Again, these are non-conforming lots. I'm really not willing to go any bigger. There's other factors in here, and I'm not afraid of a smaller size home because oftentimes that's what we're hearing people looking for is they want a smaller home. They don't want a larger home. So if this is an opportunity to have a smaller home, I'm open to that.
Okay, thanks.
Okay. Are there any additional discussions? Or additional comments, excuse me?
I have a comment.
I'm sorry, sir, not at this time.
She hasn't made a motion.
Okay. I'm sorry, sir. Unless you're called up, there will not be additional discussion from the audience. Go ahead, Commissioner.
Okay, I would like to approve OB 31, 2026 as entered into the record by John Peterson.
Second.
Is there any further discussion? Call the question. The motion carries 5-0.
Okay, next item is.
John, we're going to take a 5-minute break.
Okay.
from that. Thank you. No, yes, that's what I needed clarification on earlier.
We're just voting to give notice, so give a 30-day notice.
Okay. Hello. Sorry. Hello, and welcome back to our Cobb County Board of Commissioners zoning hearing this July 21st, 2026. We are in the midst of addressing our other business items for this meeting, and I'll turn things over to our zoning manager to queue up our next matter.
Thank you. Next case is other business item number 34 of 2026, which is to consider amending the stipulations and site plan for Casey Bowers regarding rezoning application Z76 of 1992. The property is located at the northeastern terminus of Woolrich Court and on the west side of County Line Road in land lot 155 of the 20th District. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to other business item number 34? Okay, let the record show there's no one opposed. Would the applicant please come forward to be sworn in?
Hi. Good morning.
Hi, if
Pull
you
it
can
down.
help me in stating your name, thank you.
Hi, my name is Casey Bowers. I want to say that the spelling of the street name on your little pamphlet is wrong. It's Woolwich with a W, not an R.
I'm sorry, ma'am. Okay. Thank you.
There's a T
Appreciate
in
that, the street name.
Yes.
Okay.
You're welcome. Good morning. Thank you for your time, Commissioners. I am requesting the approval to modify the existing 75-foot undisturbed buffer on my property as noted on the letter from Moore and Rogers dated July 20th, 1992, when Trayton Homes was going for their original plat zoning. This would allow for more functional backyard space, including the potential addition of a pool. The current buffer area is densely overgrown with unmanaged underbrush, and rather than serving as an effective natural screen, it detracts from the overall appearance of the property from the roadway. My intent is not to clear the area indiscriminately, but to improve and actively manage it. I plan to replace the existing overgrowth with intentional landscaping that maintains privacy while enhancing the visual character of the property. This will include appropriate plantings along the roadway to preserve screening in a more uniform and aesthetically consistent way. I will ensure that any work performed is responsible and consistent with county expectations by maintaining proper drainage, minimizing land disturbance, and implementing erosion control measures as needed. This request represents a modest modification that will improve the usability of my property while still maintaining the privacy, appearance, and environmental considerations important to the surrounding community. And I do have 2 additional letters from neighbors, and specifically the neighbor with the driveway that backs the backside of my property, in support of our zoning.
Does this complete your presentation?
It does.
All right, thank you.
Thank you.
We'll now hear from anyone who may be here in opposition. Okay, not seeing any, I'll turn things over to the district commissioner. I'm sorry, let me get staff's opinion. John, can you tell me staff's recommendation, please?
Madam Chair and Board, the staff would recommend the board deny the request.
Okay, thank you, John. All right, Commissioner, you can go ahead.
I would like to make a motion that we deny OB 34.
Is there a second?
Second.
Is there any discussion? We just ask, can we just get a zoom out of this map that's here? May you continue to zoom out. Okay, where is the buffer, the 75-foot buffer for the property?
It's all along County Line Road, Madam Chair.
For the entire development?
Yes.
Okay. Can you zoom into the one that has a pool along Woolrich? And can you go ahead and just pull this property up a little bit more so I can see what's going on the other side of Woolrich also? Can Can you drag it up? Continue, please. Continue, please. Okay, can you bring it back down? Okay. The letters from the applicant, were any of them in the neighborhood, or were they all outside of the neighborhood? You don't know?
Can we put the addresses on? Okay. This one letter is from 2517
That's the
That's the
applicant.
applicant.
County Line Road.
She's just clarified.
Oh, wait,
Way in the back.
Okay, where's the other letter from?
At 2505, which is in the middle.
Woolwich.
Yep, 2505 Woolridge.
right at the bend.
Okay.
Yeah.
So the issue for the applicant in supporting this is that there's a lot that goes into putting the buffer in place prior, or when the applicant comes for zoning. And these are conditions that someone that moves into the property should be aware of prior to moving into the property. And I know you're still asking for our consideration irrespective of it. It just becomes problematic. These are always problematic, always. And if you had some support, maybe from your homeowners association or from other property owners, I would be even a tad inclined to change it, but because there is, and knowing this, the effort that goes into protecting that buffer and to communicating with the developer to provide notice, it's difficult, at least for me, not to support this, even though I know practically it just doesn't make sense. We have another commissioner who wants to.
I know it says that she wants to remove the 75-foot buffer. So no buffer, or reduce it,
Reduce
or
it.
remove it totally, the stipulation? Is that what she,
I think it was to reduce it.
I don't see a number that says reduce it. It
Well,
says
in
she-
her comments, it was not to clear the entire thing, but to make some additions and to not just be indiscriminate in removing everything.
No, the application says the applicant would like to remove the 75 undisturbed buffer from their property. So it was to remove it. And
behind
while they are looking to put in a pool, it was staff's consideration that if they slightly reduce the size of the pool, they would still be able to put it in and not interfere with the 75-foot buffer. So therefore, I do not support removing the 75-foot buffer. I do believe there is potential that the applicant can still achieve what they would like to achieve without.
We don't have to presume anything. I heard the applicant speak that she did not want to remove the whole buffer, but let's just get some clarity from the applicant. So if the applicant can approach, we can get some clarification from you, please. Okay.
Yes.
This is a time where you're not being asked to present, but we're going to ask you questions. So if you can just let me ask before you respond.
Okay.
And if any commissioner has any questions, they can ask before you respond.
Okay.
Okay. So is it your desire to remove all the trees from the buffer?
No.
Okay. You stated your desire to have more usable space in the back. Do you know how much you would have to clear the trees to do that?
Not offhand on the tree amount. I don't have it offhand.
Okay. Do you have a usable backyard today?
Not very.
Would you be able to develop a pool in the back with the existing trees?
No.
Okay. I'm just looking at here, can we zoom into the backyard as much as possible? Just by looking at the hand that's on the map, I'm trying to get a sense of how far that buffer goes to. Are you able, is she able to point to a map somewhere and tell us? I can't see.
The outline of a fence here.
Okay, so do you have trees that are growing inside the fence on your property, or is the tree we're seeing, is that from the buffer?
I'm sorry.
The
repeat
tree that we see here in the backyard, is that growing from within the buffer area, the one that's to the north? Yeah, that area.
that. Yes.
That's in the buffer. So the tree is draping over the fence?
Yes. I believe so.
Okay. So when we say undisturbed buffer, at some point, maybe this is for legal or zoning, is it reasonable for someone that lives at a property to be able to clear the overhang of that undisturbed buffer as it stretches over that buffer line?
And this does come up from time to time, Madam Chair, where someone may want to remove a tree that's dead or dying, invasive vines, or a tree that's in bad health. And the county arborist normally lets you move them one by one as long as you have a replanting plan. If these are trees that are in imminent danger of dying or failing.
Okay, that's not necessarily the question I have, though. Here, the tree is in the buffer and it's overgrowing the buffer line. Does she have the ability to remove the branches that are hanging over the buffer line?
I'd say yes.
Okay. And does that give you usable space in your backyard for a pool?
No.
Okay. Thank you. Let me take a look at that.
I have another question for you. When did you purchase your home?
2014.
Thank you.
I'm not seeing it.
I have a question, Chair, while you're reviewing your, so for the fence, if you can like draw a line as to where the fence go, can we minimize the screen just a little, the image just a little? Yeah. If you can just take the cursor and just draw for us the outline of the fence, because the trees are covering it a bit. Does it go straight across? Does it curve? I'm just trying to get an idea.
I can't really tell from this. No, I can't either.
It looks like it curves like right there. If you can just continue the trajectory of it. Okay. Okay.
Which side is the 75-foot buffer?
Where the trees are.
Backside of it.
Okay. So right along there is where, so it curves a little, but those trees are hanging over the fence. Is that correct? Okay.
I see. I see.
So the 75-foot buffer's behind the fence.
Yes, ma'am.
Could we see a better aerial of this without?
Does this help?
Yes.
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 Thank you.
Yeah. So that's the county line roadside to the right.
Okay, there's the buffer. Okay, that's what I was trying to establish.
That's a lot of buffer.
So the buffer goes
But-
all the way to the house.
Yes.
So the pool might have to be reconfigured.
Right.
It may not be the size you want, may not be where you want it, but it's possible.
To have a
And you know that you have the ability to clear the overhang, at least to be within the buffer. So if that wasn't known before, you know now that that may help. But That's what it comes down to. That's what it comes down to. Okay. To comport with the motion. Okay, is there any other discussion? All right, we'll call the question. The motion carries 5-0. No, ma'am. Nope. We have one more.
Okay, last item on today's agenda is other business item number 38 of 2026, which is to consider amending the stipulations and site plan for Michael Heck regarding rezoning application Z19 of 2025. The property is located on the northeast side of Due West Road, northwest of Burnt Hickory Road, and at the terminus of Burnt Hickory Way, in land lot 296 of the 20th District. Is the applicant present? Okay, let the record show the applicant is here. Is there anyone here opposed to other business item number 38? Okay, let the record show there's no one opposed. All those who want to address the board either for or against, please come forward to be sworn in.
All right, you can begin whenever you're ready. Just let us know your name before speaking.
Good morning, ma'am. My name is Michael Heck. I'm the property owner.
Okay.
Do you have a picture of the?
Do you, excuse me, if we could stop time for a second. Are you waiting for something to be pulled up for you?
The site plan that was submitted?
Okay, let's get that on the screen so it's not cutting into his time.
Okay,
Is this what you're looking for?
There was an amended site plan submitted before the 15th deadline,
Okay.
and they were PDF and hard copies submitted.
Okay, let's see if we can get that before you begin. Is this what you're looking for? Hold on. Is that what you're looking for, sir?
Yes, ma'am.
Okay. Can we just go ahead and reset that clock for the applicant? All right, you can begin whenever you're ready again.
So in our process of submitting for a land disturbance permit, we had changed the orientation of one of the buildings from what was originally submitted for the original zoning, and that included a secondary driveway for the office building, which at the time when we started this, we didn't have the abandoned road bed. I was in the process of acquiring that property from the DOT, and they granted my request, and so now that road bed is part of our bigger property. So I was asking for a separate driveway entrance from my office to be separate from the retail entry that's further down the road. And there were some stipulations that Cobb DOT had asked for, and that's what my civil engineer had made those changes, and that's what's being submitted today. So the driveway for the office is really only there to service 4 people. I have 4 people that work in my office, and they're the only ones using the driveway. It's not for like public access. We don't have access to the public. And then there was a comment from the Cobb DOT that there's an awning in front of the existing building that was from the old gas station from 40 years ago. And I'm requesting or it's a canopy, I'm requesting that it stays, even though it's partially in the right-of-way, because it adds to the nostalgia of the building, because it's been there forever and the neighborhood wants it there.
All right, is there anything else you'd like to present to
No,
us? Okay. Oh, there's a balance of 8 minutes, so I just want to use that time well. If that's all that you have, I don't believe we have opposition. So I will turn to our zoning manager to get staff's recommendation, and if we have any more questions, we'll call you back up.
Thank you, ma'am.
You're welcome, thank you.
Madam Chair and Board, the staff would recommend the Board deny the request.
Okay, thank you. I'll turn things over to the district commissioner.
And I'd like to make a motion to deny OB 38 of 2026.
Okay, thank you. Is there a second?
Second.
All right, is there any discussion? Just ask if you can share the basis for the denial.
When this was approved originally, Madam Chair, there was one access for all the uses on the property, and we're adding a second access here, and the decel lane for the second access is going to really impair the lot that it's in front of as far as its future access. So, you know, staff would just prefer one access for this project instead of two.
The lot that is going to impair, is that somebody else's lot or their lot?
Yes, that's someone else's lot.
Okay, and you're saying the decel lane is going to impair access?
That's right.
What's their lot versus,
It's currently a wooded lot, I believe.
I'm sorry, I'm looking at,
The bottom lot on the south side of the old right-of-way, I think is just a wooded lot at this point in time.
oh, you're talking about the decel lane at the bottom of the screen. I'm looking at the one at the top. Is that
Yeah.
the second one that you're saying is going to be
Yes.
impaired?
Correct, the one on the bottom of the
Okay, to
screen.
accommodate the, okay. Is there opposition from the person below?
No, we have not got any opposition.
So is it going into their property?
It's along almost all their frontage.
So if they were to develop, would they not need a decel lane? I mean, I'm thinking it could be a benefit if they can just get an easement off of that as opposed to them having to then put in a decel lane. And maybe I'm not clear on what the,
If I can interject here.
Mm-hmm.
When this originally came forward for rezoning, there was a lot of opposition to it.
Okay.
And part of it was the intensity of the use.
Okay.
And as John said, that's kind of why we set on one entrance. It was going to have a decel lane to address all the other traffic concerns that we have through this Ackworth due west corridor.
okay.
So essentially, when the applicant came in, he combined both parcels to approve it as one development.
And one building?
No, because there were, and this one had unique stipulations on it because there was going to be allowable 3 buildings, but if they didn't, Farmer John's, I don't know if that rings anybody memory.
I'm from Michigan, yes.
Okay.
No Farmer John's.
Farmer John's was here. So Farmer John's was the asset on this site that the residents wanted to preserve.
Okay.
And that was kind of their basis. They wanted to preserve Farmer John's. So we essentially approved it with stipulations to keep Farmer John's, but they were going to, again, change how you accessed it. Then they were going to do the new commercial building that was, again, limited in size. That is at the top part of our screen. And then there was an existing house on the property that the applicant was going to use for their office. The house used to sit perpendicular to the property line. So this site plan is essentially tearing down the house and now building a new structure at a different angle than what was originally approved by the board.
Okay, you just told me a lot in a little bit. So what I'm trying to do is look at the old plan compared to the new plan.
Sure.
And I don't
Look
see
in
the
your book.
old house on here, but I do see one entrance for this old site plan compared to the new one.
So the original site plan that was approved is in here, but it does not include DOT's comments for the, well, it kind of had the decel lane, but it's in our book.
No, that's the new.
That was the original site plan approved.
Okay. This is so-
And again, it had a decel lane, single access. The house was supposed to be used strictly for his collector cars, which on the original site plan, you can see there was only one entrance to what appeared to be, was going to be the garage.
Okay. Okay, yes, well, I'm trying to understand this, please.
John, were the people within 1,000 feet radius notified? Is that the one that's going to be impaired by the decel lane? Is he within 1,000 feet?
Yes.
And they sent out the mailings
Yes.
properly? Okay. Just curious.
Yeah, and what is next to this used to be a car wash that is now a fencing company. But again, they've all been grandfathered.
Okay, just for me trying to understand this map, this second entrance they're proposing, does it come off of Burnt Hickory or just due west right at Burnt Hickory?
So what you're seeing here on Burnt Hickory, and so Burnt Hickory used to come all the way out to Due West Road. Back, I don't know when, but it was many, many years ago. The county closed Burnt Hickory at
Okay.
Ridge Lake Lane.
Okay.
The new Burnt Hickory came out and it's further south. I don't know if we can get that on the GIS. Yep, right down here.
Okay.
You can see where they created the new bend in the road to
Okay.
intersect, and that light became a signalized intersection.
Okay.
Because this, again, was a very dangerous area to make right in, or just any turning radius. So several months ago, the Board of Commissioners, we had in for the district to essentially abandon roadway. This is that roadway that the board approved.
Okay.
And then what the county did is DOT then conveyed it to the applicant to have as part of their property. But there are a bunch of easements and such in that road right-of-way that they now have to maintain.
Okay, so this, usually when we have a zoning application, it's not always the case, but transportation improvements are made that impact just their parcel. So what I'm hearing is this deceleration lane actually impacts part of the LRC parcel? Or is it just going into their right-of-way? I mean, right-of-way is still county-owned right-of-way, not,
It is along the right-of-way in front of the parcel, Madam Chair, but the board did zone that LRC probably 3 or 4 years ago for a retail development, and I believe the driveway is going to be going right in that area where the decel lane is starting.
oh, for the triangle property. Okay. Did they oppose this application? Or
No.
speak to it? Okay. Yeah, I guess if that's where the pain point is, that'd be the encouragement to the applicant, is to work with that property owner. Okay. Thank you for the history. Are there any other comments or questions? Okay, there's a motion and a second, and seeing there's no more comment, I am going to call the question. The motion carries 5-0. Thank you, Commissioners. With that, John and Debbie, just please clarify that that concludes our meeting.
Yes, the only other item that is listed here is a notice. We are going to be amending something previously adopted at the August hearing, and this is just the required notice so that we can do that in August.
Okay, so we can keep this on the screen then. when the meeting concludes for a little bit?
Sure. Okay.
Just to give proper notice for those who are viewing this meeting. All right, thank you all for being a part of today's discussion. Our meeting is now adjourned.